Abstract of title, the full summary of the chain of title. Actual notice, actual knowledge of a fact. Administrator, court-appointed personal representatives of an estate for someone who dies intestate without a will. May be called an administratrix if female. Adverse possession, acquiring title to land because of a long-term, open, and notorious use of the land. The required time period in Arizona is 10 years. Affidavit of value, a sworn statement under oath that indicates the purchase price paid by the buyer in a transaction, must be filled with a deed and signed by both buyer and seller. Alienation, the transfer of ownership or an interest in property from one person to another by any means. Bargain and sale deed, a deed that conveys ownership from the grantor to the grantee without any expressions of warranty. Often used in a legal proceeding. Also called grant deed. Beneficiary deed. In Arizona, a deed that is used to transfer title of real property to a beneficiary upon death of the property owner to avoid the cost and delay of probate. Chain of title, the complete record of all deeds, liens, etc. as disclosed in the public records. Constructive notice, notice given by publication in a newspaper, recording, or other method. Deed, a written instrument transferring grantor's ownership of or interest real property. Delivery and acceptance of deed, the legal act of transferring title to property to the grantee. The final step in the transfer of title. Descent, law of, a system whereby title to property passes by operation of law to the heirs of one who dies owning property without a will. Disclaimer deed, a denial of a spouse's interest in real property, signing only on or before the time of purchase. A quitclaim deed would be signing after the time of purchase. Executor, a person appointed by the testator in a will to carry out the terms of the will and to dispose of any property pursuant to the provisions of the will. Executor's deed, a deed signed by the personal representative of an estate as assigned by the testator. General warranty deed, a deed in which the grantor warrants the title against any and all defects that might have arisen before or during his or her period of ownership. Grantee, a person receiving a grant of real property from the grantor. Grantor, a person transferring title to real property. Intestate, a person who dies without making a will, causing his or her estate to pass on by laws of descent and distribution. Involuntary alienation, the transfer of title to property during the owner's lifetime without his consent. Lender's policy, a title insurance policy issued for the benefit of a lender's as well as any future holder of the loan. Generally, a lender's policy, unlike an owner's policy, covers mechanics, liens, and encroachments. Owner's policy, a type of title insurance issued in the name of the property owner. Coverage runs from the time of purchase for as long as the policyholder owns the property. Also called standard policy. Patent deed, a deed from the government to a private individual. Preliminary title report, a search of liens, encroachments, easements, and any recorded documents in the county records in order to issue title insurance. Prescription, acquiring an interest in property, usually an easement, by using it openly and without the owner's permission for at least 10 years in Arizona. In contrast to adverse possession, prescriptive use does not have to be exclusive. The owner may be using the property to, and the user does not acquire title to the property. Probate, the legal process of determining the validity of a will, paying the debts of the deceased, and distributing the remaining assets. Quiet title, a court action to remove a cloud from a title or determine who holds the title. Quitclaim deed, a deed that grants any interest in property that the grantor may have. Recordation, the act of entering a written document into the public record, i.e., giving constructive notice. Special warranty deed, a deed by which the grantor covenants or guarantees the title from the time the grantor received it until it is conveyed to the grantee. Also called limited warranty deed. Subrogation, the substitution of one claimant or creditor for another, with the substituted party succeeding to the legal rights and claims of the original claimant. Tracking, successive periods of use or possession by more than one person that are added together to equal the number of years required under state law for easement by prescription or adverse possession. Testate, someone who has dies and left a will. Testator, someone who made a will or given a legacy. Title company, a company that examines and insures title claims for real estate purposes through a thorough examination of property records. Title insurance, insurance that indemnifies the policyholder against losses resulting from undiscovered title defects and encumbrances. Title report, a report issued by the title company disclosing the condition of the title to a specific piece of property. Voluntary alienation, the deliberate transfer of title to property through a sale, gift, dedication, or grant. Agency, a relationship of trust between one person, the principal, and another, the agent, in which the agent has the authority to act on behalf of the principal. Agency creates a fiduciary duty on the part of the agent to act in good faith. Agent, one who represents a principal. In Arizona, the designated broker is the agent of the principal. Associated licensees in the office are considered subagents to the principal. Both the agent, the designated broker, and the subagents are fiduciaries to the principal. Attorney-in-fact, a person specifically designated in an instrument, e.g., power of attorney, to do something legally for another in his stead. An attorney-in-fact has a fiduciary relationship with the principal. An attorney-in-fact need not to be an attorney, at law. Client, a buyer or seller or tenant or landlord who is represented by an agent. Also called principal. Customer, a party to a transaction who is not a principal. Dual agency, an agency relationship where the brokerage firm represents both the buyer and the seller, or landlord and tenant, in the same transaction. Due diligence, an investigation to discover facts or liabilities about a property prior to its purchase. Also called discovery. Exclusive agency listing, a listing agreement where the broker is given the exclusive right to sell property, but the owner reserves the right to sell the property on his or her own without payment of any commission. Exclusive right to sell listing, a listing agreement where the broker is entitled to collect a sales commission regardless of who sells the property, including a sale by the owner of the property. Expressed agent, an agent whose authority is expressly communicated, in words or writing, by the principal. Only written authority is enforceable in court. Fiduciary, a person in a position of trust, held by law to high standards of good faith and loyalty. Fraud, an intentional perversion of the truth for the purpose of inducing another, in reliance upon it, to part with something of value or to surrender a legal right. The elements of fraud are a. Intentional misstatement of a fact, b. The misstatement of fact must be material, and c. The defrauded party must have relied on the statement. General agency, a type of principal-agent relationship in which the agent is empowered to represent the principal in a narrow area of activities. A general agent has the legal right to bind the principal in any contract within the scope of his or her responsibility. General agent and agent authorized to handle any and all of the principal's affairs in a specified job or business are, for example, a real estate broker who is a property manager. Law of agency, an area of statutory law, as well as rules, dealing with the relationships between real estate licensees and principals. Misrepresentation, a misstatement of a material fact. Net listing, a listing agreement in which the seller sets a net amount he or she is willing to accept for the property. If the actual selling price exceeds that amount, the broker is entitled to keep the excess as commission. Discouraged in most states and illegal in many. Open listing, a non-exclusive listing given by a seller to as many brokers as he or she chooses. If the property is sold, a broker is entitled to commission only if he or she is the procuring cause of the sale. Power of attorney, a legal instrument that gives a person the authority to act for another as attorney in fact. Principal. 1. The person who gives authority to an agent or attorney, thereby creating a fiduciary relationship. 2. The amount of debt, excluding interest due. Puffing, exaggerated or superlative comments or opinions. Special agency, an agency relationship in which the principal authorizes an agent to represent him in a specific activity to transaction, e.g., a real estate broker acting as an agent for a seller. Also called specific agency. Special agent, an agent authorized by the principal to perform a specific activity or participate in a specific transaction. In a typical listing, the broker is a special agent. Also called specific agent. Subagent, an agent of the designated broker who is acting as an agent for a principal, usually a seller. A subagent owes fiduciary duties to the principal. Universal agent, an agent authorized to do everything that can be lawfully delegated to representative, generally requires a power of attorney. Appraisal, an opinion or estimate of value of real property as of certain date, as supported by objective evidence and data. Appraisal methods. The three approaches to value are: 1. Market data approach, aka comparison approach. 2. Cost approach, aka summation. 3. Capitalization, aka income approach. Appraiser, someone licensed by the state who, for a fee, is expected to perform valuation services competently and in a manner that is independent, impartial, and objective. Appreciation, an increase in the value of property due to a positive improvement in the area or the elimination of negative factors. Arm's length transaction, a transaction that occurred under typical conditions in the marketplace, with each of the parties acting in their own best interest. Assemblage, the combining of two or more parcels of land into one larger parcel, usually to increase the usefulness of the land. Also called plottage. Capitalization, a method of determining the present value of income property by discounting the annual net income by a commonly used rate of return. IRV formula, income divided by rate equals value. Capitalization approach, an appraisal method which estimates the value of real estate by analyzing the amount of revenue, or income, the property currently generates or could generate, often comparing the subject property to other similar properties. Also called income approach. Capitalization rate, a rate of return, stated as a percent, used to derive a value opinion from the anticipated net operating income a property could generate. It is used for direct capitalization in the income approach. Also called cap rate. Comparable property, a property that is similar to the subject property in the appraisal process. Also called comp. Competitive market analysis, CMA, a method of determining the approximate market value of a subject property by comparing it to other similar properties in a given area that have sold, are presently for sale, or did not sell. Also called comparative market analysis. Conformity, an economic principle that says a home usually achieves maximum value when it is surrounded by homes similar in style and function. Cost, the dollars needed to develop, produce, or build something. Cost approach, a method of appraisal based on the cost new of an improvement, minus any depreciation, plus site value. Often used when comparable sales cannot be found, as with unique properties or public buildings, or for custom homes or new construction. Also called summation method. Curable depreciation, a loss in value of a property that is economically feasible to repair or replace. Deferred maintenance, a physical deterioration that has occurred because of a failure to perform maintenance and upkeep. Depreciation. 1. The decrease in value to real property improvements caused by deterioration or obsolescence. 2. A loss in value as an accounting procedure for use as a tax deduction for income tax purposes, also called cost recovery. Directional growth, the direction in which a city or community grows. Economic life, the time during which a building can be used for its intended purpose or generate more income than is paid out for operating expenses. Economic obsolescence, a loss of value due to a change in external events or factors affecting a piece of real property, cannot be cured by the owner. Also called external obsolescence or social obsolescence. Effective age, the age the structure appears to be based on physical wear and tear, functional design, and external factors. Effective age is generally not the same as actual or chronological age, except in new construction. Effective gross income, EGI, potential gross income less vacancy and collection losses. Functional obsolescence, a loss in value due to a property's design characteristic that does not meet current market expectations. Gross rent multiplier, GRM, a conversion factor derived from the sale price of a comparable rental property divided by the estimated rent of the subject to estimate its value. Highest and best use, the most profitable, legally permitted, feasible, and physically possible use of a piece of property. Income approach, an appraisal method estimates the value of real estate by analyzing the amount of revenue, or income, the property currently generates or could generate, often comparing the subject property to other similar properties. Incurable depreciation, a situation in which the cost of the repair is more than the value added to a property. Insurance value, the amount for which property can be insured, usually representing only the replacement cost of the structure and disregarding any value for land. IRV formula, a simple calculation for finding the net operating income, the rate, or the value of an investment property. When any two factors are known, the third can be determined. Also known as capitalization rate formula. Market data approach, an appraisal approach that estimates the value of real property by performing a market analysis of the comparable properties in the area where the subject property is located. Data are collected and adjustments made for differences. Also called sales comparison approach or comparison approach. Market price, the contract price for which a property actually sold. Market value, the most probable price a property should bring on an open and competitive market when sold to a ready, willing, and able buyer through an arm's-length transaction. Narrative appraisal report, a written type of appraisal that allows the appraiser to comment fully on the options and conclusions of the appraisal. Net operating income, NOI, income after all operating expenses have been deducted, but before debt service and taxes are considered. Obsolescence, a loss of value due to a decrease in the usefulness of property caused by decay, changes in technology, people's behavior patterns and tastes, or environmental changes. Orientation, the placement of a building on a lot, the relationship of a building to its surroundings. Plottage increment, the assemblage of two or more parcels of land into one larger parcel, resulting in an increase in value over the combined value of individual parcels. Also called plottage or assemblage. Principle of anticipation, an economic principle that says value is created by the expectation of future benefits, such as profit on resale, pleasure, tax shelter, production, income, etc. Anticipation is the foundation of the income approach to appraisal. Principle of contribution, the theory that a specific item or feature of a property is worth only what it actually contributes in value to that parcel of real estate. Progression, a principle that says the value of a smaller and less expensive home is positively affected when it is surrounded by larger and more expensive homes. Usually said about the worst home in the best area. Reconciliation, the final step in the appraisal process that involves analyzing the values derived from the different appraisal approaches to arrive at a final opinion of value. Also called correlation. Regression, a principle that says the value of a larger, more expensive home is negatively affected when it is surrounded by smaller, less expensive homes. Usually said about the best home in the worst area. Replacement cost, the method of determining the value of an improvement under the cost approach in an appraisal by building the structure using current materials and methods of construction. Reproduction cost, the method of determining the value of an improvement under the cost approach in an appraisal by building an exact replica of the structure using authentic materials. Residual value, the value of an improvement that is left over at the end of its useful or economic life. Also called salvage value. Sales comparison approach, an appraisal approach that estimates the value of real property by performing a market analysis of the comparable properties in the area where the subject property is located. Data are collected and adjustments made for differences. Also called market data approach or comparison approach. Sales price, the price a buyer paid for a property. Salvage value, the estimate of value of a property at the end of its useful or economic life. Also called residual value. Substitution, an economic theory that says an informed buyer will not pay more for a property or a feature in a property than a comparable substitute. Summation approach, a method of appraisal based on reproduction cost new of an improvement, minus any depreciation, plus site value. Often used when comparable sales cannot be found, as with unique properties or public buildings, or for custom homes or new construction. Also called cost approach. Supply and demand, an economic principle that says that for all products, goods, and services when supply exceeds demand, prices will fall, and when demand exceeds supply, prices will rise. Unearned increment, an increase in the value of real property through no efforts of the property owner, e.g., rezoning or a population shift in the area. Utility, a characteristic indicating that something, for example, real property, has a usefulness to it. Value, the regard that something is held to deserve, the importance, worth, or usefulness of something. There are several measures of value, depending on the purpose. Eviction, the legal process of removing a tenant from possession of property because of a breach of the lease agreement. a court action where a tenant loses possession of a leased premises by the act of a landlord because of a wrongful act by the tenant, usually for non-payment of rent. Also called forcible entry and detainer. Forcible entry and detainer, Fed, action, a summary legal action to regain possession of real property, especially a lawsuit filed by a landlord to evict a defaulting tenant and regain possession of the property. Also called ejectment. Landlord, the owner of property who leases it, the lessor. Lessee, a tenant. Lessor, a landlord. Acknowledgement, a formal declaration made before a notary public by a person signing a document. This prevents fraudulent and forged documents, such as a deed. Addendum, items of additional material that are attached to an existing contract to explain, modify, or revoke elements of the contract. Arbitration, a method for resolving disputes out of court whereby an impartial third party renders a binding decision. This is the method by which disputes between realtor brokers may be resolved. Arizona Administrative Code, AC, the official rules of the state of Arizona promulgated by the state agencies, boards, and commissions that have rulemaking authority. Assign, the act of transferring one's rights. Assignee, the person who receives rights under an assignment. Assignment. 1. The transfer of one person's interests under a contract to another. 2. The transfer of a tenant's right of possession or other interest in leased property to another person for the remainder of the lease term. In both cases, assignment does not release the assignor from the obligations stated in contract. Assignor, the person who transfers rights under an assignment. Backup offer, a possibility when a home seller has accepted an offer from a buyer but is still accepting offers from other buyers in the event the original offer falls through. Bankruptcy, a court process that cancels some debt and provides some relief for creditors. Chapter 7, sometimes called a straight bankruptcy, is a liquidation proceeding. Chapter 13, sometimes called a reorganization proceeding, is filed by individuals who want to pay off their debts over a period of 3 to 5 years. Chapter 11 is a bankruptcy proceeding that provides for reorganization, usually involving a corporation or partnership. Bilateral contract, a contract in which the parties expressly enter into mutual agreements or engagements, e.g., a real estate sales contract. Each party promises to perform some act. Blind ad, an advertisement that does not include the brokerage company name and appears that the property is offered for sale by the owner. Boilerplate, standardized language used in contracts for the sake of efficiency and completeness. Caveat emptor, a Latin phrase meaning, let the buyer beware. The rule states that a buyer is expected to examine property carefully, instead of relying on the seller to point out problems. Competent. 1. Of sound mind, for the purposes of entering a contract or executing a will, not suffering from mental illness, retardation, or senility. 2. Of sound mind and having reached the age of majority. Consideration, something of value given to another for entering into a contract. Contingency, provision in a contract or deed that makes the parties' rights and obligations depends on the occurrence or non-occurrence of a particular event. Contract, an agreement that the law will enforce. The elements of a contract are mutual assent, offer and acceptance, consideration, competent parties, legal subject matter, and sometimes that the contract be in writing if required by the statute of frauds. Counteroffer, a response to an offer to enter into a contract, changing some of the terms of the original offer. A counteroffer is rejection of the original offer, not a form of acceptance, and does not create a binding contract until it is agreed upon by both parties. Earnest money deposit. Money given by a buyer upon signing a sales contract, showing the buyer's intention to carry out the terms of the contract. Earnest money is an inducement and show of good faith, not consideration, and is not necessary for a valid contract to exist. Executed contract, a contract that has been performed by the parties. Note, in the vernacular, people use executed to mean signed, but this is not the legal definition. Executory contract, a valid contract that has not been fully performed, such as a signed real estate contract prior to closing. In such cases, the buyer would receive legal title. Expressed contract, a contract that has been put into words, either spoken or written. First right of refusal, the right to match a bona fide offer when a seller decides to offer the property for sale or lease to a third party. Also called right of preemption. Hold harmless clause, a contract provision that relieves one party of liability for damages that are caused during the execution of the contract. Also called exculpatory clause or indemnification clause. Implied contract, a contract based on one's actions or deeds. Incompetent, not legally competent, not of sound mind nor of legal age. Latent defect, a defect that is not visible or apparent, a hidden defect that would not be discovered in a reasonably thorough inspection of property. Lawful object, a legal purpose that must be present in a contract for it to be valid. Liquidated damages, a sum of money to which the parties to a contract agree in advance, at the time of entering into the contract, will serve as compensation in the event of a contract breach. Listing contract, an agreement between a broker and a seller. Marketable title, title to real property that is reasonably free of defects and encumbrances, may require an unbroken chain of recorded title going back for a statutory number of years. Also called merchantable title. Material defect, any property condition that might affect the consideration paid by the buyer/customer. Material fact, any fact that is relevant to a person making a decision. Agents must disclose martial facts to buyers. Mediation, the process whereby cases already filed with the court are accelerated by referring certain matters to a court referee. Meeting of the minds, the mutual agreement to all terms and conditions set forth in a contract by the parties involved, required for a valid contract. Also called mutual assent or offer and acceptance. Minor, a person under the age or 18. Nominee, a person or corporation named to act as a representative for another when the principals wish to remain anonymous in the conveyance of real property. Offer, a proposal to purchase or lease real property, requires intent to contract and definite terms. Offeree, a person who receives an offer or to whom an offer is made. Offeror, a person who makes an offer. Option, the right to buy, sell, lease, rent, or exchange real property for specific terms within a specified time frame. This is unilateral contract binding only the seller. Optionee, the buyer who has a right to purchase or lease property under the terms of an option agreement, but is not obligated to do so. Optioner, the property owner who is obligated to sell or lease property under the terms of an option agreement if the optionee exercises the option. Property management agreement, a written agreement that governs the relationship between a property owner/investor and the property manager and outlines the duties of the property manager. Purchase contract, a contract in which a seller promised to convey title to real property to a buyer in exchange for the purchase price. Also called purchase contract, contract for sale, or agreement to sell. Rejected offer, offer to purchase that a seller does not accept, must be kept for at least 1 year. Rescission, the annulment of a contract by mutual consent of the parties. Verb form, to rescind. Specific performance, a legal remedy by which a court orders someone who has breached a contract to perform as agreed, rather than simply paying monetary damages. Statute of frauds, a law requiring that certain instruments be in writing to be enforceable, for example, contracts to sell real estate or leases for 1 year or less. Time is of the essence, a contract clause that emphasizes punctual performance on the essential elements of the contract. Unenforceable, a contract that a court would refuse to enforce because it is missing one or more of the essential elements. Unilateral contract, a contract that is legally binding only on the one party who made a promise. Valid, the legal classification of a contract that is binding and enforceable in court of law. Void, having no legal force or effect, e.g., a contract with an illegal purpose. Voidable, a contract that one of the parties can disaffirm because it lacks a legal requirement or there's a negative factor, such as fraud or duress. Antitrust, an area of federal law concerned with maintaining competition in private markets by prohibiting unlawful restraint on trade. Ethics, moral principles, rules, and standards of conduct. Home inspection, a careful and detailed examination of a home structure and systems by a person who is licensed or registered in the profession. Mortgage banker, a company that originates loans to borrowers, as opposed to a bank or a savings and loan. In Arizona, mortgage bankers are regulated by the state banking department. Mortgage broker, a person licensed by Arizona State Banking Department who brings a borrower and lender together for a fee. Sherman Antitrust Act, the federal law that makes it illegal for real estate brokers to set uniform commission rates, price fixing, and prohibits other acts of collusion that could limit free competition in the marketplace. Tie-in agreement, an antitrust violation in which one transaction or agreement is contingent on a second transaction or agreement, also called trying agreement. Deed in lieu of foreclosure, a deed to property voluntarily given by a borrower to the lender to satisfy the debt and avoid foreclosure, also called voluntary conveyance. Default, failure to fulfill an obligation, duty, or promise. Deficiency judgment, a personal judgment against a borrower if the lender/creditor does not receive the amount of the lien plus the costs associated with foreclosure at a foreclosure sale. Equitable right of redemption, the right of a debtor to redeem the property from foreclosure proceedings prior to a confirmation of sale, also called equity of redemption. Forbearance, a legally binding promise to refrain from doing a particular act. Foreclosure, a procedure through which property is sold to satisfy a debt, may be judicial or non-judicial. Forfeiture, the loss of a right or something of value as a result of failure to perform an obligation or condition. Judicial foreclosure, a lawsuit filed by a lender or other creditor to foreclose on a mortgage or other lien, a court-ordered sheriff's sale of property to repay the debt. In Arizona, the borrower has both the equitable right of redemption before the sale and statutory right of redemption after the sale. The statutory period of redemption is 6 months or 30 days if the borrower has abandoned the property. Junior lien, any lien that is a lower priority than another lien. Lease pendens, a recorded document giving constructive notice of a pending legal action against a specific piece of property. Naked legal title, an interest in real property that lacks the usual rights and privileges enjoyed by an owner, for example, that which is held by a trustee in a deed of trust. Also called bare legal title. Non-judicial foreclosure, foreclosure by a trustee under the power of sale clause in a security instrument without the involvement of a court, not used in all states. Real estate owned, REO, property acquired by a lending institution through foreclosure and held in inventory. Also called bank-owned. Redemption period, statutory period in mortgage during which a borrower can redeem the title to the real property. Reinstatement period, in deed of trust, the period of time the trustor has to pay all costs, fines, and fees prior to the trustee sale. Sheriff's certificate, a document that the highest bidder receives at a sheriff's foreclosure sale, judicial foreclosure. Also called certificate of sale. Sheriff's deed, a deed issued by the court to a property purchaser from a foreclosure sale under a judgment. Sheriff's sale, a property auction, judicial foreclosure sale, ordered by the court to pay back the lender when the borrower defaults. Statutory right of redemption allows a mortgagor, debtor, to redeem property for set period of time after a foreclosure sale, regardless of the timing of other events. The time frame for statutory right of redemption after a judicial foreclosure in Arizona is 6 months. It is 3 years after a tax lien action. Treasurer's deed, a deed issued by a county treasurer to the person who is the successful bidder at a property tax lien sale only after the 3-year period of redemption has expired. Trustee 1. A person appointed to manage a trust on behalf of its beneficiaries. 2. An independent third party that holds the trust in a deed of trust for the benefit of the lender. Trustee's deed, a deed executed by a trustee, transferring title from the trust to the successful bidder at a trustee's sale. Trustee's sale, a non-judicial foreclosure sale under a deed of trust. Blue sky laws, laws regulating the sale of securities intended to protect consumers from fraud. Disclosure, any information report given to a party in a transaction. National Do Not Call Registry, national registry managed by the Federal Trade Commission that limits commercial telemarketers from phoning consumers who place their telephone numbers on a list. Assessment, the levy to be paid to the government for services provided or constructed by it, e.g., curbs, sewers, sidewalks. Sometimes referred to as a special assessment. Attachment, court-ordered seizure of a defendant's property to satisfy a judgment. In the case of real property, attachment creates a lien. CC and RS, covenants, conditions and restrictions, a declaration of covenants, conditions and restrictions, usually recorded by a developer to create a general plan of private restrictions for a subdivision. Covenant, an agreement as a legal contract. Covenants, conditions and restrictions, CC and RS, a declaration of covenants, conditions and restrictions, usually recorded by a developer to create a general plan of private restrictions for subdivision. Deed restrictions, private limitations on the use of property, contained in the deed as a means of controlling the quality or character of a subdivision or specific piece of property. Encroachment, the unauthorized intrusion of a fixture or real property improvement onto the property of another, e.g., the roof of a building which extends over the property line into a neighbor's property. Encumbrance, any claim, lien, or liability which clouds the title to real property, but does not prevent its conveyance. General lien, a lien against all property of a debtor instead of a particular piece of property. Homestead, a person's land used as their residence, the equity in which is usually exempt from attachment by creditors to a statutorily preset amount, $150,000 in Arizona. Involuntary lien, a lien that arises by operation of law without the consent of the property owner. Also called statutory lien. IRS lien, a government claim against property to protect its interests in a tax debt. Judgment. 1. A court's binding determination of the rights and duties of the parties in a lawsuit. 2. A court order requiring one party to pay damages to the other. Lien, a non-possessory interest in property, giving a lien holder the right to foreclose if the owner does not pay a debt owed the lien holder. Mechanic's lien, a specific lien claimed by someone who performed work on the property, construction, repairs, or improvements, or supplied materials and has not been paid. Also called material man's lien. Principal residence, the dwelling that a taxpayer physically occupies and personally uses. A person can have only one principal residence. Specific lien, a lien that attaches only to a particular piece of property. Voluntary lien, a lien placed against property with the consent of the owner, a mortgage or deed of trust. Writ of attachment, a recorded legal writ giving the court custody of real property until a creditor's suit is settled. Writ of execution, a court order directing the sheriff to seize and sell as much of the defendant's property as necessary to satisfy the debt and the expense of the sale. Arizona Department of Environmental Quality, ADQ, the state department tasked with protecting and enhancing public health and the environment in the state, enforces the state's environmental laws and delegated federal programs to prevent air, water, and land pollution and ensure cleanup. Asbestos, fibrous material derived from a naturally occurring group of minerals commonly used in insulation. Asbestos fibers released into the air are carcinogenic. Brownfield, real property whose expansion, redevelopment, or reuse may be complicated by the presence or potential presence of a hazardous substance, pollutant, or contaminant. Encapsulation, the process of applying a sealant to asbestos-containing material, which penetrates the material's surface, preventing the release of the dangerous fibers into the air. Environmental Protection Agency, EPA, the federal agency tasked with creating and enforcing environmental pollution problems and providing research on environmental issues. Expansive soil, oil that expands when is added and shrinks when it dries out, can cause damage to building foundations. Federal Emergency Management Agency, FEMA, an agency that supports citizens and first responders to prepare and respond to natural disasters, has management oversight of the National Flood Insurance Program. Fissure, a narrow crack or opening in the ground, often associated with basin subsidence that accompanies extensive groundwater mining. Also called earth fissure. Friable, a characteristic of asbestos in which it can crumble easily or become powdery when manipulated by hand, releasing particles into the air. Lead-based paint disclosure, the disclosure of known information on lead-based paint and lead-based paint hazards before the sale or lease of most housing built before 1978. Mold, a fungus that can release toxins into the environment, causing allergic reactions in some people. Percolation, the process of water seepage through the ground. Percolation test, a procedure that measures the draining characteristics of the soil on a lot. It is required for the proper design of septic tank drain fields. Also called perk test. Radon, a naturally occurring radioactive gas that emanates from the earth. It is odorless, colorless, and tasteless, but may cause cancer if allowed to build up in high concentrations. Remediation, the act of stopping or reversing something specific, often environmental damage. Subsidence, the gradual caving or sudden sinking of the Earth's surface in response to natural or man-made causes. Superfund site, a parcel of land that has been contaminated by hazardous substances that may endanger public health or the environment, and that has been identified by the Federal Environmental Protection Agency as a candidate for cleanup. Water Quality Assurance Revolving Fund, WARF, a fund maintained by the Arizona Department of Environmental Quality, ADQ, to provide funds for cleanup of sites where groundwater and/or soil contamination is present. Close of escrow, CE, a real estate transaction that has been complete and the sale is final. Credit, a sum of money to be received. Debit, any sum of money owed, a charge on a closing statement. Escrow, a system in which things or value are held on behalf of the parties to a transaction by a disinterested third party until the specified conditions have all been met. Escrow account, an account in which the lender maintains the borrower's extra 1/12 monthly deposits to cover next year's insurance and tax payments. Also called impound account, reserve account, or reserve fund. Escrow agent, the person charged with coordinating the activities and documentation necessary for completing a real estate transaction, usually the one who assists in preparing the settlement statement and conducting the closing. Also called closing officer, settlement officer, escrow officer, or closing agent. Escrow company, a neutral clearinghouse through which title to real property is closed and/or escrow funds are held in trust. Foreign Investment Real Property Tax Act, FIRPTA, a federal law that subjects the disposition of a U.S. real property interest held by a foreign person to income tax withholding. Proration, the allocation of expenses, real estate taxes, or rents between buyer and seller in proportion to their actual use of an item. Trust account, a bank account, separate from a real estate broker's personal and business accounts, used to segregate trust funds from the broker's own funds. Also called fiduciary account. Americans with Disabilities Act, a 1990 federal law that prohibits discrimination based on a person's disability and enforces consistent standards in employment. Title I, Public Services. Title II, Public Accommodations. Title III, and Telecommunications. Title IV. Blockbusting, an illegal act whereby owners are encouraged to sell their properties because minorities are moving into their neighborhood. Also called panic selling or panic peddling. Civil Rights Act of 1866, a federal law that prohibits discrimination based on race, color, or ancestry without exception. Conciliation, a method for resolving fair housing complaints whereby the individual against whom a complaint was filed assures that the violation will be remedied. Disability, a physical or mental impairment that substantially limits or curtails one or more major life activities. Discrimination, bias or unfair treatment. Equal Credit Opportunity Act, ECA, federal law that prohibits discrimination in granting credit to people based on sex, age, marital status, race, color, religion, national origin, or receipt of public assistance. Fair Housing Act, the common name for Title VIII of the Civil Rights Act of 1968, a law that prohibits discrimination in all facets of the home buying process on the basis of race, color, national origin, religion, sex, familial status, or disability. Familial status, a protected group under the Federal Fair Housing Act, making it illegal to discriminate against persons because they are the parent or guardian of a child less than 18 years of age, or because they are pregnant. Handicap, a physical or mental impairment that substantially limits or curtails one or more life activities. Also called disability. Protected classes, a group of people with a common characteristic who are legally protected from discrimination on the basis of that characteristic. Redlining, the illegal process of a lender denying loans in certain areas of a community because of race, color, creed, etc. Steering, channeling prospective buyers or tenants to particular neighborhoods based on race, religion, national origin, ancestry, or other legally protected class. Acceleration clause, a clause in loan documents that allows the lender to call the note all due and payable if the borrower breaches the terms. Adjustable rate mortgage, ARM, a mortgage loan that has an interest rate on the note that periodically adjusts based on an index that reflects the cost to the lender. Also called variable rate mortgage. Alienation clause, a clause used in a financing document allowing the lender to demand the full and immediate payment of the mortgage because the owner transferred ownership of the property. Also called due on sale clause. Amortization, payment of debt in regular, periodic installments of principal and interest, as opposed to interest-only payments. Annual percentage rate, APR, the relationship between the cost of borrowing and the total amount financed, represented as a percentage. Assumption of mortgage, an agreement by a buyer to assume the liability under an existing note secured by a mortgage. Balloon payment, a lump sum payment that is due at the end of a note term because the note used paid only part of the principal and/or interest. Also called partially amortized mortgage. Blanket loan, a single loan where two or more different parcels of property are offered as security for loan. Bridge loan, a short-term loan that occurs between the termination of one loan and the beginning of another. Also called gap loan or swing loan. Budget loan, a loan agreement where payments include principal and interest on the loan, plus 1/12 of the year's property taxes and hazard insurance premiums. Carryback, property lien in which a seller assumes the lender's role and carries the unpaid balance of the purchase price as a loan to the buyer. Certificate of eligibility, a statement issued by the Department of Veterans Affairs to establish the status and amount of a veteran's eligibility to qualify for a guaranteed loan. Certificate of Reasonable Value, CRV, a document issued by the Department of Veterans Affairs that states the value of the subject property based on an approved appraisal. A VA guaranteed loan amount cannot exceed the CRV. Conforming loan, a loan that meets the qualifying standards established by Fannie Mae or Freddie Mac and, thus, can be sold on the secondary market. Construction loan, interim financing used during construction of a building, a short-term loan. Also called interim loan. Consumer Financial Protection Bureau, CFPB, an agency funded by the Federal Reserve with rulemaking and enforcement authority over many consumer financial laws, including the Truth in Lending Act and the Real Estate Settlement Procedures Act. Established under Title X of the Wall Street Reform and Consumer Protection Act. Conventional loan, a loan that is not guaranteed or insured by a government agency. Debt coverage ratio, DCR, used to determine a company's ability to generate enough income to cover the expense of a debt, calculated as net operating income divided by debt service. Also called debt service coverage ration. Defeasance clause, 1. A clause used to defeat or cancel a certain right upon the occurrence of a specific event. For example, requiring a lender to give a borrower a release of the lien once the loan is repaid. 2. Clause used to give a borrower the right to redeem real estate after default on a note by paying the full amount due plus fees and court costs. Due on sale clause, a clause used in a mortgage allowing the lender to demand the full and immediate payment of the mortgage because the owner transferred ownership of the property. Also called alienation clause. Equity, the amount of an owner's interest in a parcel of real estate which is the fair market value of the real estate in excess of the mortgaged indebtedness, calculated as value. Outstanding mortgage equals equity. FHA insured loan, a mortgage loan insured by the Federal Housing Administration that protects the lender against losses from default. Fixed-rate mortgage, a loan that has an interest rate that remains constant for the duration of the loan. Interest rate, the amount that is charged or paid for the use of money, generally expressed as a percentage of the principal. Loan-to-value, LTV, the amount of money borrowed, compared to the value or price of the property, expressed as a percentage. Non-disturbance clause, a loan clause whereby a lender agrees not to terminate leases with tenants in the event of a foreclosure. Open-end loan, a loan allowing the borrower to request more funds from the lender, up to a certain predefined limit, without having to renegotiate the loan. Package loan, a loan where personal property, such as appliances, is included in the property sale and financed together with one loan. Pity, a typical mortgage payment that includes principal, interest, taxes, and insurance. Any required homeowners association fees are also included. PMI, private mortgage insurance. Insurance offered by private companies to insure a lender against a borrower's default on a loan. Point. 1% of the loan amount, a fee charged by a lender for making a loan, calculated based on the loan amount. Prepayment clause, a contract clause that gives a lender the right to charge the borrower a penalty for paying off the loan early. Prepayment penalty, additional money charged by a lender to the borrower for paying off a loan early. Private mortgage insurance, PMI, insurance offered by private companies to insure a lender against a borrower's default on a loan. Rate lock, a guarantee that the lender will deliver the negotiated interest rate if a loan closes by a specified date. Release clause, a clause that provides for the release of parcels out of a blanket mortgage. Reverse mortgage, a loan that allows qualified homeowners age 62 or older to convert home equity into a lump sum, a monthly cash stream, or a line of credit. Loan due when the last surviving borrower dies, sells the home, or cease to live in the home for 12 consecutive months. Also called reverse annuity mortgage. Subordination clause, a contract clause that gives a mortgage recorded at a later date the right to take priority over an earlier recorded mortgage. Swing loan, a short-term loan that occurs between the termination of one loan and beginning of another. Also called gap loan or bridge loan. Takeout loan, long-term financing that is used to pay off a construction loan when construction is complete. Variable rate mortgage, a mortgage loan that has an interest rate on the note that periodically adjusts based on an index that reflects the cost to the lender. Also called adjustable rate mortgage. Warehousing, the process of gathering loans together for sale to investors in the secondary market. Wraparound, a carryback financing arrangement in which an existing loan on a property is retained while the buyer makes a payment large enough to cover the existing loan and new obligation. Agreement for sale, a carryback document between buyer and seller. The seller does not give a deed to the buyer until paid in full. Therefore, the seller retains legal title and the buyer has equitable title. Also called land contract, contract for deed, installment sale, vendor's lien, or contract for the sale of real estate. Beneficiary. 1. One who receives a benefit. 2. The lender in a trust deed. Contract for deed, a carryback document between buyer and seller. The seller does not give a deed to the buyer until paid in full. Therefore, the seller retains legal title and the buyer has equitable title. Also called land contract, agreement for sale, installment sale, vendor's lien, or contract for the sale of real estate. Deed of reconveyance, a deed that a trustee signs and gives to the trustor, the borrower, to convey title back to the trustor when the loan, deed of trust, has been paid in full. Compare satisfaction of mortgage. Deed of trust, a third-party security instrument that conveys naked title to a trustee. The borrower, called the trustor, has legal title. The trustee has bare legal title. The lender is the beneficiary. In Arizona, a deed of trust is more common than a mortgage because a deed of trust allows the trustee to sell the property if the trustor defaults, thereby bypassing the judicial foreclosure procedure using a power of sale clause. Once the note is repaired, the trustee clears the lien against the property, also called trust deed. Equitable title, any present right to acquire legal title to property. Hypothecation, the pledging of the property to be the security for a loan without giving up possession of it, as with a mortgage or deed of trust. Land contract, a carryback document between buyer and seller. The seller does not give a deed to the buyer until paid in full. Therefore, the seller retains legal title and the buyer has equitable title. Also called agreement for sale, contract for deed, installment sale, vendor's lien, or contract for the sale of real estate. Legal title. 1. The interest in property held by the rightful owner. 2. The seller's interest in property under a contract for sale. Lien theory, a concept of financing where loans, such as real estate mortgages, are regarded as liens. Title remains with the borrower. Mortgage, a security instrument that creates a voluntary lien on real property to secure repayment of a debt. Mortgagee, the lender. Mortgager, the borrower. Note, a written, legally binding promise to repay a debt. Also called promissory note. Promissory note, an instrument that evidences a promise to pay a specific person within a specific time frame. A written, legally binding promise to repay a debt. Satisfaction of mortgage, a document that a creditor gives to a borrower upon the full repayment of a loan, releasing the mortgage lien. It should be recorded. Title theory, the financing concept under which a mortgagee or beneficiary holds naked title to property until the loan is repaid. Trust deed, a three-party security instrument that conveys bare legal title to a trustee. The borrower, called the trustor, has legal title. The lender is the beneficiary. In Arizona, a deed of trust is more common than a mortgage because a deed of trust allows the trustee to sell the property if the trustor defaults, thereby bypassing the judicial foreclosure procedure using a power of sale clause. Once the note is repaid, the trustee clears the lien against the property, also called deed of trust. Trustor, the borrower under a deed of trust. Vendee, the buyer in an agreement for sale or a land contract. Vendor, the seller in an agreement for sale or a land contract.
Ad valorem taxes assessed on real property based on its value.
Assessed value, the value of real property used as a basis for calculating property taxes. Assessor, the county official who determines the value of property for property tax purposes. Certificate of Purchase, CP, the complete record of all deeds, liens, etc., as disclosed in the public records. Community Facilities District, CFD, a special-purpose public improvement district in Arizona that has the ability to levy long-term bonds to finance and provide public infrastructure, such as water, sewer, schools, and streets. Condemnation. 1. The act or process of taking private property for public use through the government's power of eminent domain, also called appropriation. 2. A declaration that a structure is unfit for occupancy and must be closed or demolished. Eminent domain, the power or right of governmental bodies to take private real estate for public use upon payment of just and equitable compensation to the owner. The legal process of taking the property is called condemnation or appropriation. Escheat, the reversion of property to the state after a person dies without leaving a valid will or any heirs. Full cash value. In Arizona, the value of land and improvements as the basis for determining the taxable value of a property tax assessment, synonymous with market value. Government rights. Remember Pete. Police power, eminent domain, taxation, and escheat. Limited property value, LPV. In Arizona, the number used to complete taxes cannot exceed the property's full cash value. Police power, the right of the government to pass legislation protecting the safety, health, and welfare of the public. Property taxes, a tax levied on the value of real property, also called real estate taxes. Special assessment, a tax levied on against properties that benefit from public improvement, e.g., a sewer or streetlight, to cover the cost of the improvement, creates an involuntary lien. 1031 exchange, a transaction that, under provisions of Section 1031 of the Internal Revenue Code, allows a taxpayer to sell an investment property and purchase another investment property in its place without paying capital gains on the proceeds from sale. Also called like-kind exchange or tax-deferred exchange. Adjusted basis, the purchase price of a property, basis, minus accumulative depreciation, plus acquisition cost, plus capital improvements. Boot, taxable, not like-kind property used in an exchange, such as cash or other personal property that is used to balance an exchange of real property. Capital gain income, the gain from the sale of capital asset, i.e., one held investment purposes. Cash flow, the net spendable income from an investment after operating and fixed expenses, including debt service. If expenses exceed income, the cash flow is negative. CAH on cash return, the bottom line of any investment expressed as a percentage divided by the down payment settlement costs. Independent contractor, self-employed person paid for jobs completed rather than hours worked, and responsible for settling his or her own hours and paying his or her own taxes. Like-kind property, used in a tax-deferred exchange referring to assets considered to be the same type. Limited liability company, LLC, a type of business structure that shares some characteristics of both a corporation and a partnership, or sole proprietorship if just one owner. Limited partnership, a partnership made up of one or more general partners who are responsible for the partnership and one or more limited partners who are investors and whose liability is limited. Real Estate Investment Trust, REIT, joint venture with at least 100 investors through which real estate is purchased, If 90% of the income is distributed to the investors, it qualifies for single taxation. Straight-line depreciation, a depreciation method that divides the total depreciation evenly over a stated number of years. Tax-deferred exchange, a transaction that, under provisions of Section 1031 of the Internal Revenue Code, allows a taxpayer to sell an investment property and purchase another investment property in its place without paying capital gains on the proceeds from sale. Also called 1031 exchange or tax-deferred exchange. Acre, 43,560 square feet. Baseline, a primary line running east to west that establishes references in the rectangular survey system of legal land description. Correction lines, in the rectangular survey system, lines running every 24 miles that are used to make a correction to compensate for the curvature of the earth. Also called check lines. Fractional sections, those sections along the north and west sides of a township containing less than 640 acres that compensate for the curvature of the earth. There are 11 fractional sections and 25 full or standard sections. Gila and Salt River Baseline and Meridian, G and SRB and M, the initial point of the rectangular survey system in Arizona, located on Monument Hill south of the confluence of the Gila and Salt Rivers. Government check, an area consisting of 16 townships, a quadrangle in the rectangular survey system of legal land description that includes correction lines. Also called government lot. Government survey system, federal government system that divides land into sections, townships, and ranges using baselines and principal meridians. Also called rectangular survey systems. Lot and block description, a method of legal description for subdivisions, identifying a parcel of land by reference to lot and block numbers within a subdivision, as specified on a subdivision plat map that is recorded in the county where the property is located. Also called recorded plat. Meridian, in the rectangular survey system of land description, a primary line that runs north and south and that intersects the principal east-west baseline. Also called principal meridian. Metes and bounds, a type of legal description that describes a site by boundary must begin and end at the point of beginning, PB. Mile, a unit of linear measurement equal to 5,280 feet. Miles square, a parcel of land described by the number of miles wide, which describes the area, length x width. Plat map, a tract surveyed land showing location and individual boundaries in a subdivision, town, or section. Principal meridian, in the rectangular survey systems of land description, a primary line that runs north and south and that intersects the principal east-west baseline. Range, in the rectangular survey system, a 6-mile strip of land running north/south. Range lines, in the rectangular survey systems, north-south lines that run parallel to principal east-west boundaries. Recorded plat, a method of legal description for subdivisions, identifying a parcel of land by reference to lot and block numbers within a subdivision, as specified on a subdivision plat map that is recorded in the county where the property is located. Also called lot and block system. Rectangular survey system, federal government system that divides land into sections, township, and ranges using baselines and principal meridians. Also called government survey system. Section, an area of land in the rectangular survey system that is a 1 mile by 1 mile square. One section equals 640 acres, and 36 sections are contained in a township. Tier, in the rectangular survey system, a 6-mile strip of land running east/west. Township square divisions of land, 6 miles by 6 miles in the rectangular survey system. One township contains 36 sections, 36 square miles, 23,040 acres. Buffer zone, a tract of land between two differently zoned areas. Building codes, a set of rules that stipulate the standards for constructing building structures. Downzoning, the change in an area's zoning from a higher to lower status, such as commercial to residential. General plan, a long-range, overall plan by government to ensure the orderly development and use of property. Also called master plan. Interstate Land Sales Full Disclosure Act, a federal law that protects consumers from fraud and abuse in the sale or lease of land. The act is regulated by the U.S. Department of Housing and marketing schemes that entice consumers to purchase land sight unseen. Master planned community, specific areas with a full variety of retail, commercial, and governmental services available. A virtually self-contained area. Nonconforming use, the use of a site or structure that was legal before a change in zoning and is permitted to continue, though it does not comply with current zoning law. Setback, a term used in local zoning ordinances that represents the distance between a lot's boundary lines and improvements. Use variance, a variance that permits an owner to use the property in a way that is not ordinarily allowed in that zone, e.g., a commercial use in a residential zone. Variance, a permit obtained from the local zoning authority allowing the holder to use property or build a structure in a way that violates the zoning ordinance. Zoning, government regulation of the uses of property within specified areas. The classification of land by types of uses permitted and prohibited in a given district, and by densities and intensities permitted and prohibited, including regulations regarding building location on lots. Actual eviction, the physical removal of a tenant from a leased property with the tenant relieved of any further responsibility to pay rent. Certificate of occupancy, a document certifying a building codes indicating it is fit for occupancy. Common area maintenance, CM, all costs incurred in operating, repairing, and maintaining the common areas of a commercial property, the fees for which are usually prorated among all tenants. Constructive eviction, a landlord's act or failure to act that interferes with the tenant's quiet enjoyment of the property or makes the property unfit for its intended use to such an extent the tenant is forced to move out. Contract rent, the amount of rent stated in the terms of the lease. Demise, the transfer of possession in an estate to another by lease. Distraint, the seizure of someone's property in order to obtain payment of money owed. Economic rent, what the property could rent for in the open market if currently vacant and available, also called market rent. Escalation clause, a clause in a lease or mortgage allowing the holder to increase the rental rates or interest rate under specific circumstances. Estate at sufferance, possession of property by tenant who came into possession of the property under a valid lease, but stays on after the lease expires without the landlord's permission, or a seller who remains in the property after the close of escrow. Estate at will, a leasehold estate with no specified termination date and with no regular rental period. Excess rent, resulting difference when the contract rent exceeds the economic rent, to the advantage of the lessor and the disadvantage of the lessee. Graduated lease, a lease with an escalator clause that calls for increases/decreases in rent at specified intervals. Also called graded lease. Gross lease, a lease for which the tenant pays a fixed amount to the landlord and the landlord is responsible for paying all expenses. Also called flat lease or straight lease. Ground lease, a long-term lease under which the tenant leases only the land from the owner, but the tenant owns the building. Also called land lease. Holdover tenant, a tenant who remains on the property after the lease has expired. Index lease, a lease in which the amount of the rent is tied to some common index indicator, such as the Consumer Price Index or the Wholesale Price Index. Lease, a written contract between the property owner, lessor, and a tenant, lessee, where the possession of land and/or buildings is granted by the owner to the tenant, usually for a specific time period. Lease option, a lease that includes an option for the tenant to buy the property at a predetermined price during the lease term, usually with a portion of the lease payments applied to the purchase price. Leasehold, possession of property by a lease. Net lease, a lease agreement that requires the lease tenant to pay some of the operating expenses and other costs associated with the property, which could include taxes, insurance, etc. Percentage lease, a lease for which the tenant pays a minimum base rent plus a percentage of gross sales. Period-to-period estate, a leasehold estate that continues for successive periods of equal length until terminated by proper notice from either party. Also called periodic estate or estate from period to period. Proprietary lease, an exclusive, long-term lease that conveys a leasehold interest to an owner of shares in a cooperative. Sale-leaseback, a method for a seller to free capital for business expansion by property to a buyer who has agreed to lease the same property back to the seller. Sandwich lease, the transfer by a tenant of only part of the right of possession or other interest in leased property to another person for part of the remaining lease term. Also called sublease or sublet. Sublease, the transfer by a tenant of only part of the right of possession or other interest in leased property to another person for part of the remaining lease term. Also called sandwich lease or sublet. Subleasee, the new tenant under a sublease. Subleaser, the original tenant who becomes the lessor, landlord, under sublease. Surrender, a premature conveyance of a present estate to the future estate, such as when a lessee surrenders a leasehold interest to the owner before the expiration of the lease. Tenant, the person who has the right of possession under a lease. Also called lessee. Tenant improvements, TI. In commercial real estate, changes made to the interior of a property to accommodate the needs of tenant, the costs of which are negotiated between lessee and lessor in the lease agreement. Assumable loan, a financing arrangement in which the outstanding loan amount can be transferred to someone else. Estoppel agreement, a document stating that certain facts are true as of the date the contract is signed. Estoppel certificate, a legal instrument used by a lender so that beyond a certain date, the borrower agrees that the loan balance is correct if no dispute is made, and thus there is no defense to challenge it. This is generally used when a note is sold, and so is for the benefit of the investor who buys the note. These may also be used when commercial property is sold and the tenants verify the terms of the lease. Fannie Mae, Federal National Mortgage Association, or FNMA, the nation's largest investor in residential mortgages. Federal Housing Administration, FHA, a part of the U.S. Department of Housing and Development. It insures mortgage loans made by participating lending institutions. Freddie Mac, Federal Home Loan Mortgage Corporation, or FHLMC, an organization that buys residential mortgages in the secondary market. Federal Home Loan Mortgage Corporation, FHLMC, a non-profit, federally chartered institution, now privately owned, that functions as buyer and seller of residential mortgages. Gap Loan, a short term that occurs between the termination of one loan and the beginning of another, also called swing loan. Ginnie Mae, Government National Mortgage Association, or GNMA, a government entity operating under the Department of Housing and Urban Development, HUD, to promote investment by guaranteeing the payment of principal and interest on federally insured or guaranteed mortgages through its mortgage-backed securities program. Graduated payment mortgage, a payment structure that allows the borrower to make smaller payments in early years of the mortgage, with payments increasing on a scheduled basis at a predetermined point until they are sufficient to fully amortize the loan over the remainder of its term. Interest 1. A right or share in something, such as a piece or real estate. 2. A charge a borrower pays to a lender for the use of the lender's money. Interest-only loan, a loan where scheduled payment s only pay accrued interest and do not pay any portion of principal, requiring a balloon payment at the end of the loan term. Also called straight loan or term loan. Interim financing, temporary financing used during construction of a building, a short-term loan. Also called construction loan. Legal rate, the interest rate that applies if no rate has been agreed to. Leverage, the use or borrowed money to finance an investment calculating a profit or loss will result not only from the investment, but the borrowed money as well. Loan servicing, the ongoing process of collecting payments, keeping record, and handling defaults for loans. Also called servicing. Lot releases, the release of parcels under a blanket mortgage. Negative amortization, an increase in the balance of a loan hen payments are not enough to cover the interest. Novation, the release of liability of the original party to an agreement, for example, a borrower on a note or a tenant on a lease, and the substitution of a subsequent borrower or tenant with the approval of the lender or landlord. Primary mortgage market, lenders who originate loans directly to borrowers. Reduction certificate, a document in which a lender verifies the balance and terms of a loan, used primarily when the loan is being assumed for the benefit of the buyer who is taking over the loan. Also called letter of assumption. Reserve fund, an account in which the lender maintains the borrower's extra 1/12 monthly deposits to cover next year's insurance and tax payments. Also called impound account, reserve account, or escrow account. Secondary mortgage market, private investors and government agencies that buy and sell mortgages. Straight loan, a loan where scheduled payments only pay accrued interest and do not pay any portion of principal, requiring a balloon payment at the end of the loan term. Also called interest-only loan or term loan. Subordinate mortgage, any mortgage that is lower in priority to another senior lien on the property. Subordination, a written agreement between lien holders on a property to change the priority of mortgages, judgments, and other liens. Also called subordination agreement. Term loan, a loan where scheduled payments only pay accrued interest and do not pay any portion of principal, requiring and balloon payment at the end of the loan term. Also called straight loan or interest-only loan. Usury, charging an illegal rate or amount of interest on a loan. Errors and omissions, E&O, insurance, an insurance that protects real estate licensees from liability due to mistakes or negligence. Flood insurance, a financial instrument that protects real property owners from water damage to the structure and contents of their property. Home warranty, a contract between a homeowner's and a home warranty company that provides coverage for the covers, repair, or replacement of named components of the home for a specified period of time. Homeowners Association, HOA, a nonprofit association comprised of homeowners in a subdivision, responsible for enforcing the subdivision's CC and RS and managing other community affairs. Homeowners Association fees, charges imposed on a property owner to pay for upkeep, maintenance, and sometimes hazard insurance of common property, could include special assessment for specific projects. When required as a condition of ownership, the monthly amount must be added to PITI to get complete housing expense. Failure to pay can result in an HOA assessment lien. Homeowners insurance, an insurance policy that will cover loss or damage to the home or property in the event of fire or other disaster. Affidavit of a fixture, a document for owners of mobile/manufactured homes recorded to certify the home is legally affixed and is real property. Air rights, the right to undisturbed use and control of the airspace over a parcel of land, within reasonable limits for air travel, may be transferred separately from the land. Appurtenance, something that belongs to property and passes with property. An appurtenance runs with the land. Bill of sale, an instrument in writing that transfers ownership of tangible personal property, e.g., furniture. Bundle of rights, legal rights conferred to owners of real property, including rights to mortgage, sell, make improvements, enjoyment, lease, and use property. Community property, property accumulated by legal spouses through the efforts of either during their marriage. Community property laws provide that each spouse has an equal interest in the property so acquired. However, the spouses can own property sole and separate from the community. Arizona is one of only 8 states that recognize community property. In Arizona, there is no right of survivorship under community property. Upon the death of a spouse, half of the property passes to the deceased spouse's heirs, with the surviving spouse retaining his or her half share in the community property. Concurrent tenancy, ownership by more than one person, also called co-ownership or co-tenancy. Condominium, a property developed for co-ownership, with ACH co-owner having a separate interest in an individual unit, combined with an undivided interest in the common areas of the property. Conventional life estate, and estate created by deed, or that may be for the tenant's own life or the life of another. Conversion. 1. The illegal use of funds being held in trust. 2. Changing an existing rental apartment building into a condominium. Cooperative, a shareholder interest in a corporation that owns the property, entitling the shareholder to exclusive use of a unit in the property as a proprietary tenant. Corporation, a legal entity that is a form of business operation managed by board or directors. Dedication, the donation of real estate to a government for a public purpose. Defeasible fee, and estate that reverts back to the grantor if a condition is broken. Also called fee simple determinable or fee simple on condition subsequent. Dominant tenement, property that receives the benefit of an appurtenant easement. Also called dominant parcel. Easement, the non-ownership right acquired by a person to use the land of another for specific purpose. An easement is irrevocable and creates an interest in the property. Easement appurtenant, the right acquired by the owner of one parcel of land to use the adjacent land of another for a specific purpose. There must be 2 tracts of land. One tract is called the dominant tenant, the tract that benefits from the easement. The other tract is called the servient tenant, the tract that is burdened by the easement. Easement by necessity, an easement given to a landlocked owner by the court system to provide a way of ingress and egress for the landlocked land. Easement by prescription, gaining the right to use another's property through adverse, long-term use. In Arizona, This requires 10 years of adverse use. Also called prescriptive easement. Easement in gross, an easement that benefits a person or company rather than benefiting another parcel of land, can be personal or commercial. Egress, the way to exit a property, usually refers to a road or other means of access to a piece of property. Emblements, farm crops that require annual cultivation, which may be removed by a tenant farmer if the owner sells land, considered to be personal property, and so emblements are transferred through a bill of sale. Also called fructus industrialis. Erosion, a gradual loss of soil due to natural causes, such as the movement of wind or water. Estate. 1. A possessory interest in real property, either a freehold estate or a less than freehold, leasehold. 2. The real and personal property left by someone who has died. Estate for life, an interest in real personal property, the duration of which is limited by the life of its owner or another designated person. Also called life estate. Estate for years, a leasehold estate set to last for a definite period, after which it terminates automatically. Also called term tenancy or tenancy for years. Estate in remainder, a future interest that becomes possessory when a life estate terminates. It is held by someone other than the grantor of the estate. Estate in reversion, a future interest that becomes possessory when a temporary estate, such as a life estate, terminates, and that is held by the grantor or grantor's successors in interest. Fee conditional, a type of defeasible fee estate where title may be terminated by former owner if conditions stated in the deed aren't met. A former owner has a power of termination. Fee determinable, a defeasible fee estate where title is terminated automatically if certain conditions occur. Fee simple, the greatest estate one can have in real property, freely transferable and inheritable, and of indefinite duration, with no conditions on the title. Fixture, a man-made attachment, an item of personal property that has been attached to or closely associated with real property in such a way that it is now legally part of the real property. Freehold estate, estates of an indefinite duration that are actually owned. Less than freehold estates are leases. Front footage, the dimension across the access side of a parcel of land. The access could be a road, railroad tracks, or water. When referring to lot size, frontage is the first number, also called frontage. General partnership, a form of business ownership in which each partner has equal right to manage the business and share in the profits, as an equal responsibility for debts. Ingress, the way to enter a property, usually refers to a road or other means of access to a piece of property. Intangible, those rights in personal property that cannot be touched, e.g., patents, trademarks, royalties, copyrights. Joint tenancy with right of survivorship, tros, an interest held by two or more persons in property where each person holds an equal share of interest in the undivided whole and shares equal liability for payment. If one joint tenant dies, that interest automatically passes to the surviving joint tenants by the right of survivorship. Land, the actual surface of the earth, from a legal standpoint, also refers to everything under the ground to the center of the earth, and everything over the land into the air, within limits to allow for air traffic. Landlocked, property that has no ingress/egress to a public street, requiring the owner to cross land owned by someone else. Life estate, a freehold estate that is not inheritable, the duration of which is limited by the life of the measuring life, either the owner of the life estate or another designated person. Also called Estate for life. Life estate in remainder, a life estate that passes to another named person upon the death of the measuring life. Life estate in reversion, a life estate that reverts back to the grantor upon the death of the measuring life. Life tenant, someone who owns a life estate, the person entitled to possession of the property during the measuring life. Literal rights, surface water rights of landowners whose land touches a navigable, non-flowing body water such as a commercial lake, sea, or ocean. Merger, uniting two or more properties by transferring ownership of them all to one person. Mineral rights, the rights that a property owner has to surface and subsurface minerals on a tract of land. Natural person, a real human being, as opposed to an artificial person such as a corporation. Personal property, tangible item that are not permanently attached to or are part of real estate. Any property that is not real property, movable property not affixed to land. Also called chattel or personalty. Quiet enjoyment, the right of an owner or lessee to use and possess real property without interference from the previous owner, the lessor, or anyone else claiming title. Real estate, the physical land itself to the center of the earth and the sky above, and anything permanently affixed to the land, such as buildings, improvements, growing plants, and fixtures. Real property, the physical land itself to the center of the earth and the sky above, and anything permanently affixed to the land, such as buildings, improvements, growing plants, and fixtures, as well as the associated rights, such as water rights or easements. Also called realty. Remainder man, a third party who has a future interest in property, a remainder estate, upon the termination of a life estate. Reversion, a future interest that becomes possessory when a temporary estate, such as a life estate, terminates and that is held by the grantor or grantor's successors in interest. Reversionary rights, a right held by a property owner re-enter and regain possession of leased property at the termination of a lease. Right of survivorship, the characteristic of a joint tenancy by which the surviving joint tenant, owner, automatically takes all rights, title, and interest of the deceased joint tenant. Riparian rights, water rights of landowners whose land abuts natural body of water, such as a stream or river. No permit is required. Not recognized in Arizona. Security agreement, a document that creates a lien or personal property under Uniform Commercial Code, UCC. Servient tenement, property burdened by an easement. The owner of the servient tenement, the servient tenant, is required to allow someone who has an easement, the dominant tenant, to use his property. Also called servient parcel. Severalty ownership, property owned by one person. Also called sole and separate or separate property. Sole and separate, property owned by one person. Tenancy, the lawful possession of real property, an estate. Tenancy at sufferance, possession of property by a tenant who came into possession of the property under a valid lease, but stays on after the lease expires without the landlord's permission, or a seller who remains in the property after the close of escrow. Also called estate at sufferance. Tenancy at will, a leasehold estate with no specified termination date and with no regular rental period. Also called estate at will. Tenancy by the entirety, a form of property co-ownership by legal spouse, in which each spouse has an undivided one-half interest and the right of survivorship, with neither spouse able to convey or encumber his or her interest without the other's consent. This form of ownership is not available in Arizona. Tenancy for years, a leasehold estate set to last for a definite period, after which it terminates automatically. Also called term tenancy or estate for years. Tenancy in common, a type of concurrent ownership in a property by two or more persons without right of survivorship. Tenants in common can will or sell their interest to anyone. Upon the death of a tenant in common, the decedent's interest in the property goes to any named heirs, not surviving co-tenants. Title, the right to or ownership of land. Trade fixture, an item of personal property that is annexed to leased property and is necessary to a trade or business. Trade fixtures are removable by the tenant prior to expiration of the lease. Trust, fiduciary relationship in which one party gives another party the right to hold title to property or assets for the benefit of a third party. UCC, one financing statement, a legal form that a creditor files with the state to give notice that it has or may have an interest in the personal property of a debtor. Uniform Commercial Code, UCC, a standard set of business laws that regulate financial contracts. The UCC has been adopted by most states in the U.S. Unities of joint tenancy, the 4 unities of time, title, interest, and possession that are required for a joint tenancy. Unity of interest, each co-owner has an equal interest, equal share of ownership in a property. Unity of possession, each co-owner is equally entitled to possession of the entire property because the ownership interests are undivided, the only unity required for tenancy in common. Unity of time, each co-owner acquired title at the same time. Unity of title, each co-owner acquired title through the same instrument, deed, will, or court order. Property management, leasing or renting, or offering to lease or rent, real property of others for a fee, commission, compensation, or other valuable consideration pursuant to a property management employee contract. Advisory Board, a 10-member board, appointed by the governor, that advises and gives recommendations to the Commissioner of the Arizona Department of Real Estate. Members serve a 6th term, meet quarterly. Affidavit of Disclosure, a disclosure document that may be required when selling property that is either in an unincorporated area, not in a city or town, and not in a subdivision, or if 5 or fewer parcels are involved in the transaction. It provides information about certain aspects of the property and allows the buyer an opportunity to rescind the contract. Arizona Administrative Code, AC, the official rules of the state of Arizona promulgated by the state agencies, boards, and commissions that have rulemaking authority. Arizona Department of Real Estate, ADRE, the state agency that regulates real estate, cemetery and membership camping brokers and salespersons. The department oversees the activities of licensees, investigates complaints, and participates in administrative hearings. It also regulates the sale of subdivisions, unsubdivided lands, timeshares, condominiums, memberships, campgrounds, and cemeteries. Arizona Revised Statutes, ARS, the codified collection of laws that have been passed by the Arizona State Legislature. Article 26, Article of the Arizona Constitution that permits licensed, active real estate brokers and agents to prepare the documents necessary in a real estate transaction handled by their brokerage without charging a fee. Also written as Articles of Associate Broker, a licensed broker who is employed by another broker, unless otherwise specifically provided. An associate broker has the same license privileges as a salesperson. Broker, a person licensed under the laws of the state to transact real estate business on behalf of another, acting as an agent. In Arizona, A broker must have 3 years of experience and can be a designated broker or an associate broker. Broker's trust account, a bank account, separate from a real estate broker's personal and business accounts, used to segregate trust funds from the broker's own funds. Also called trust account. Cease and desist order, a court or administrative order requiring the cessation of certain activities. Commingling, illegally mixing personal funds with money held in trust on behalf of client. Commissioner, the person who heads the Arizona Department of Real Estate. Appointed by the governor, the commissioner has no set term. Prior to appointment, the commissioner must have at least 5 years of experience in real estate, banking, or title/escrow business. Commissioner's rules and regulations adopted by Arizona Department of Real Estate and published in the Arizona Administrative Code, AC, in Title IV, Chapter 28. Consent order, a negotiated settlement between the Arizona Department of Real Estate and a licensee when enforcement and compliance finds evidence to support discipline. Once signed by a DRE and the licensee, it becomes effective immediately and cannot be appealed. Designated broker, the principal broker who is responsible for the acts of all licensees under his or her license. In Arizona, each real estate company has one designated broker. Employing broker, an entity licensed by the Arizona Department of Real Estate to operate a brokerage business. Improved lot, a parcel of lot of a subdivision upon which a structure exists or on which a contract has been entered into that obligates the subdivider developer to construct a structure within 2 years from the date of the contract of sale. Licensee, someone who has met the requirements and been issued a broker's license or a salesperson's license. Lot reservation, an agreement between a developer and buyer, usually accompanied by a deposit, obligating the seller to sell, but not obligating the buyer to buy until after they have had the opportunity to review the public report. Lot split, land that is divided into 5 or fewer parcels. Property management trust account, a checking account used to deposit property management money. Must be reconciled monthly and financial records retained for 3 years. Public report, a disclosure document that a developer must give to buyers before they sign a contract that includes important facts about a property that would be essential to their decision-making. Also called subdivision disclosure report, commissioners or public report. Recovery fund, a fund administered by real estate commissioner from which an aggrieved person can claim money if financially harmed by the action of a licensee. Stigmatized property, a property that is undesirable to most people because of a past event, such as a crime or death. Such stigmas as not considered material facts that must be disclosed. Subdivided land, multiple parcels of land that have been split off from a larger parcel of land. Subdivider, a person or entity that subdivides land. Temporary broker's license, a license issued to a spouse, next of kin, or other responsible for the purpose of closing the business if the broker dies, disabled, or is otherwise unable to perform. Not to exceed 90 days. Timeshare, the ownership of a single unit multiple persons for fixed or floating increments of time over the course of a year. Trust account, a bank account, separate from a real estate broker's personal and business accounts, used to segregate trust funds from the broker's own funds. Also called fiduciary account. Unimproved Lot A parcel or lot upon which there is no structure nor any contract to construct one within 2 years. Unsubdivided land, land that is divided or proposed to be divided into 6 or more lots of at least 36 acres, yet less than 160 acres. Closing disclosure, a statement prepared by the lender itemizing loan costs and terms as required for RESP-related transaction, must be provided to the borrower at least 3 business days prior to loan consummation. Discount points, an added loan fee charged by a lender to increase the yield on a lower-than-market interest rate loan and make it competitive with other higher interest loans. 1 point equals 1% of the loan amount. Every point that the lender receives will increase their return by approximately 1/8 of 1%. Floating rate, any type of debt instrument, such as a mortgage, that does not have a fixed rate of interest over the life of the instrument. Also called adjustable rate or variable rate. Housing and Urban Development, HUD, an agency of the federal government which oversees many federal housing programs. Impound account, an account in which the lender maintains the borrower's extra 1/12 monthly deposits to cover next year's insurance and tax payments. Also called escrow account, reserve account, or reserve fund. Loan estimate, a lender disclosure containing a good faith estimate of closing cost, loan terms, and the costs that the borrower must pay for a real estate loan, including the annual percentage rate, APR. The lender must give this to the borrower within 3 business days of a completed loan application. Required by RESPA and the Truth in Lending Act for all federally related residential transactions. MIP Mortgage Insurance Premium. The fee charged for FHA mortgage insurance coverage. Initial premium can be financed, and there is a monthly premium. Mortgage Insurance Premium, MIP, the fee charged for FHA mortgage insurance coverage. Initial premium can be financed, and there is a monthly premium. Also called Upfront Mortgage Insurance Premium, UFMIP. Non-conforming loan. A loan does not meet the qualifying standards set by Fannie Mae and Freddie Mac and thus cannot be sold on the secondary market. Origination fee, a fee charged by a lender to cover the administrative costs of making a loan, usually based on a percentage of the loan amount. Purchase money mortgage, a loan to a borrower from the seller as a portion of, or for the entire amount of, the purchase price of a property. Also called seller financing or owner financing. Real Estate Settlement Procedures Act, RESPA, federal law dealing with real estate closing that provides specific procedures and guidelines for the disclosure of settlement costs. Implemented by Regulation X, which is under the oversight of the Consumer Financial Protection Bureau. Regulation Z, the rules implementing the Truth in Lending Act that require borrowers to be shown how much they are going to pay for credit in dollars and annual percentage rate, APR, and full disclosure of credit terms in advertising once any specific financials are mentioned. Small Business Administration, SBA, a federal agency that makes loans to small businesses. Subprime loan, a loan with a higher interest rate than a conventional loan, generally due to the creditworthiness of the borrower or the size of the loan amount. TRID rule, the TILA-RESPA Integrated Disclosure Rule, issued by the Consumer Financial Protection Bureau to create standardized, consumer-friendly disclosure documents, including the loan estimate and the closing disclosure. Trigger terms, a word or phrase that describes a loan, including the down payment, terms, and monthly payment. If an ad uses a trigger term, additional disclosures are required to comply with the Truth in Lending Act. Truth in Lending Act, TILA, federal law that requires disclosure of the terms of credit by a creditor to a prospective borrower. Implemented by Regulation Z, which is under the oversight of the Consumer Financial Protection Bureau. U.S. Department of Veterans Affairs, VA, an agency of the federal government that guarantees mortgage loans for eligible veterans. USDA Rural Development. Loan programs from the U.S. Department of Agriculture guarantees loans or makes direct loans for the purchase of an existing home, construction or a new home, renovations or repairs, relocation of a home, or the purchase of site for the loan. VA Guaranteed Loan, a guaranteed loan made to eligible veterans for the purchase or construction of a home. Active Management Area, AMA, defined areas within Arizona where water management programs, such as restrictions governing groundwater use, are in place. Adequate water supply, the standard required from developers outside of an active management area, AMA. If adequate water supply cannot be demonstrated, the developer must disclose this fact in all advertising and promotional material. Arizona Departments of Water Resources, ADWR, the State Department created in 1980 to secure long-term dependable water supplies for Arizona's communities, enforces the state's groundwater code and surface water rights. Assured water supply, the demonstration that sufficient water of adequate quality will be continuously available to satisfy the needs of the proposed development for at least 100 years. Required from developers within an active management area, AMA. Central Arizona Project, CAP, a 336-mile canal/aqueduct that diverts water from the Colorado River for delivery to central and southern Arizona, managed by the Central Arizona Water Conservation District, CAWCD. Doctrine of prior appropriation. In water rights law, the legal doctrine that the first person to take a quantity of water source for beneficial use, agricultural, industrial, household, has the right to continue to use that quantity of water for that purpose. First in time is first in right. Effluent, water that has been collected in a sanitary sewer for subsequent treatment in a facility that is regulated. Exempt well, a well that has a maximum pump capacity of 35 gallons per minute and is used to withdraw groundwater only for non-irrigation purposes, including watering less than 2 acres of grass or garden. Floodplain, land that is covered by the 200-year or regional flood, that has a 1% chance of occurring in any given year. Groundwater, subsurface water controlled by the Arizona Department of Water Resources. Groundwater Management Act, statute that sets limits on who can use groundwater, where it can be used, and enforced by the Arizona Department of Water Resources, ADWR. Groundwater overdraft, excess use of groundwater, resulting in the creation of active management areas, AMAs, within Arizona. Irrigation grandfathered rights, excess use of groundwater, resulting in the creation of active management areas, AMAs, within Arizona. Irrigation grandfathered right, under the Arizona Groundwater Code, the right to use groundwater to irrigate specific acres of land that were irrigated with groundwater between 1975 and 1980. Irrigation Non-Expansion Area, INA, areas identified by the Arizona Groundwater Code where irrigated acreage is restricted. Overdraft, drawing more groundwater than is being replaced. Prior appropriation. In water rights law, the legal doctrine that the first person to take a quantity of water from a water source for beneficial use, agricultural, industrial, household, has the right to continue to use that quantity of water for that purpose. First in time is first in right. Surface water, water that is above the ground in a stream, regulated by the Arizona Department of Water Resources. Type 1 right, in Arizona, a grandfathered water right that remains with the land but could be used for non-irrigation purposes. Type 2 right, in Arizona, a grandfathered water right that may be sold separate from the land. Water table, the natural level at which ground is saturated, be it above or below the surface of the ground. Wetlands, ecosystems where the land is permeated with water, which either lies on or near the surface of the land.